Newsfirst Newsline with Faraz Shauketaly.
And very good evening to you and welcome to Newsline Live. Now, one of the most crucial issues faced by the majority of Sri Lankans is an apparent lack of awareness of the law. The law on litigation, whether it be civil law, criminal law, labor law, or even the law pertaining to fundamental rights. And in this context, we as a network, we're trying to put out greater awareness of the law. It's one of the things that the public have asked us, and we continuously try and do that whenever we can. And we've got here tonight a lawyer who's no stranger to our program, to our network, Mr. Harshana Nanayakkara. Very good evening to you, Harshana.
Evening. And
thank you very much for coming on the program. Now, how important is it for members of the public to understand the law and the various remedies and so on that are available to it, especially because I asked this question, you know, we have presidential commissions of inquiry of several such inquiries and so on, and now we have another inquiry that is looking at political victimization, and it appears that one is to counter the findings of the other. It appears that way, okay? Not specifically the presidential commissions, but to counter some other legal action. And therefore, it seems even there is confusion even at the top, as in the legislature, which is why we have all these different commissions. What's going on, and how important is it for the public to know?
To answer the first part of your question, that is very important, because see, we have a maxim in the saying that not knowing the law is not an excuse.
Of course.
Right? So everybody is subjected to the law. But yet, the awareness is so minimal, mainly because if you are saying that, it will be nice to have as an A-level subject some general law.
Yeah.
Because it's very important for every citizen to know their basic rights. I'm not saying that every citizen must study all the laws in depth, but at least the general law. I mean, to be a law-abiding citizen, it's very important to know the basics of law, and I just wish there's more programs to educate the public on these things. To answer the latter part about presidential commissions and other things, believe me, there's no confusion in the law. But some people who handle the law might want some confusion for their gain. Yeah. But the law is absolutely fine. Of course, there are dated legislations. I'm not saying no, which we have to attend to. Having said that, I will not engage in the commission of inquiry at this juncture. But yes, to answer you, it's very, very important. And also, why it is so important for people to know the law? Now, sometimes people don't know the difference between granting of bail.
Yeah.
They say, oh, he's been released. No, it's been granting of bail. So when people don't understand how these laws operate, what the judges do, that in turn gives them they become suspicious of the judges, they become suspicious on the Attorney General. Some of those suspicions are very justified, but most of them are due to not being aware, if you look at Facebook.
Especially for the public, when they look at various cases, and there are the cases may have several similarities, but when it comes to, let's say, the granting of bail, some are not given bail, some are given bail.
The reason is very simple. Everybody goes by what the paper reporter says or the Facebook says.
Right.
But the reality is only the judge
who
gives the bail.
Let's take a very quick example. We have on one case where a person who's convicted for murder is allowed to come and attend Parliament. I find that odd.
I find that extremely odd because, in my view, I don't want to get entangled too much in it.
No.
Because if you look at it, you are disqualified. By Constitution, you are disqualified the moment you are convicted.
Yeah.
Right? So, that conviction came along even before the election.
Yeah.
So, from that time onwards, you are disqualified.
Yeah.
And a conviction does not get overturned by the fact that you filed an appeal. The appeal has to continue to be heard. At the end of the appeal, you must be acquitted.
Right.
So right now, the particular person you're talking about is still a convict. But of course, then there was a separate case filed whether he could come into the Parliament.
Right.
Then, of course, Attorney General and the Supreme Court got together and gave an interpretation to the Constitution.
Saying that he can.
That he can attend Parliament.
Right.
Not to say that he's acquitted and he has not done it wrong,
Right.
but he can attend Parliament.
Because his conviction is on hold for effect, or in effect?
Yes, because that
But then
conviction
he's
has now turned into a remand prisoner. But what I'm trying to say is this. It has not been overturned.
Right.
He's still a convict. Only the running of his sentence, which is on hold, not his conviction. It is a conviction.
Right.
So forget about the law. Where's the decency? That's my question. But anyway, Supreme Court gave that ruling, and some people are
Sometimes, as a result, probably as a result of a lack and awareness of the law, people find themselves in court, and yet this is it is wrongful, and then finally they may be cleared. Is that kind of a case? Would you refer to that as a malicious prosecution?
Well, it depends, because when you say malicious prosecution, it's actually a civil remedy which you file in a civil court for damages,
Right.
for injuring your character or emotions or stress, but also it's applicable in criminal law, and as of decided cases, it's applicable in civil law as well.
And
Now-
have you got any sort of examples of malicious prosecution?
I mean, there have been a plethora of cases in the local jurisdiction. I actually bought a few, like Anuradha Purananda Vimulatero versus Dhammati Seherath is one of them. Karunaratna versus Karunaratna was one of them.
Right.
These are civil cases and criminal cases alike.
Right.
So there are enough cases. Now, you must understand, not every acquittal in a criminal case or not every verdict that somebody wins, malicious prosecution is not an automatic thing. There are certain requirements that has to be met first prior to a malicious prosecution remedy is available.
And malicious prosecutions is there in civil cases as well?
Oh, definitely. There was this one, Villas versus Joyce.
Yeah.
That's a case where they extended it to the civil law as well. But it is very settled law even in Sri Lanka.
Yeah.
It is available for civil cases as well. But there are elements that need to be satisfied.
Indeed, yeah. This is what Sir Thomas Bingham, the Master of the Rolls, said here. The rule of public policy, which has first claim on the loyalty of the law, that wrongs should be remedied. And that is precisely what it's all about. The person who feels that he was maliciously prosecuted wants to, not only has he been cleared, but will then want the other party who brought it against him, if it was indeed malicious, without a real, well, I should be asking you that. What constitutes malice then?
What constitutes malice? It can't be just simple ill will or just hatred or just suspicion. Malice has to be the dominant motive. Mm-hmm. That means it says now there are a couple of requirements for a malicious prosecution. One of them is that absence of a probable cause for instituting prior proceedings, the one that got dismissed. And malice as the primary source of prior action.
Yeah.
Now, when you say malice, it can't be just a mistake, right? It is just that when there's no reasonable grounds, no honest man, no sensible man in that position can come to the conclusion with the given circumstances, if not for the fact motivated by malice. That means all other reasonable and probable causes are missing, and the only dominant motive is malice.
Right. So basically, the existence of malice can be established either by showing what the motive was and that it was wrong, or by showing that the circumstances were such that the prosecution can only be accounted for by imputing some wrong or indirect motive to the prosecutor. Malice may be inferred from want of reasonable and probable cause, but it is not a necessary inference.
Absolutely, that's spot on. That's what I said earlier also, but I broken down the elements.
Yeah.
As I told you, it's not automatic.
Yeah.
Everything depends on the circumstances. What is required is, you just giving some information to the police station, and then on that information the police files a case and the other person get acquitted. That doesn't itself means it's malicious. provided the person who made the complaint had a reasonable and honest belief, and a person in his position could have come to that was okay. But if it has been more that has been actively involved in creating more case with the police, more active involvement, then that goes on to show, like bringing in a witness whom he knows is false, or getting an affidavit which he knows deliberately it's false. So those things will are the things that the judges will look at when you are looking at malice, the absence of probable and a reasonable cause as a reasonable, prudent person.
The public must have been shocked in recent months when they found out, or the last year and so on, when they found out that even policemen have been charged, some have been convicted, some have been charged or accused of introducing evidence, introducing weaponry, and so on. These are very serious matters.
Frankly, yes, there are some officers who investigated also now in remand prison for introducing evidence. But again, of course, this is a very serious matter when it happens. And if you ask me whether it doesn't happen at all, no, my God, it doesn't. It has happened. We know certain instances where things have been planted, where the judges in their order says so.
Yeah.
But again, we have to be careful when the public feels that some certain investigators are being not prosecuted but persecuted simply because they made investigation against some corrupt people of the current government, perhaps. I do not know.
Yeah.
But these things can happen and they should be investigated. But what we should not do is just go by media reports and just affirm them saying this is wrong and this is bad, they did it. But can it happen? Yes, it has happened before.
The role, of course, of the media is not only to report the news, but also to explain the news.
Spot on, because the last thing the media should be doing is making your reader emotional.
Yeah.
Instead, you make them knowledgeable.
Yeah.
Give them the story, give them the facts. Give them the facts and the story which is against you also. So they can come to a conclusion. In that way, this is one of the reasons why I enjoy your show much, because you give the facts to the people. This is why I enjoy this show.
Well, yes, and one of our taglines, of course, is that, we report, you decide.
Exactly.
And that drives us all here.
And some cheap publicity, some cheap media are really causing a lot of mayhem especially in social media. Because for them...
Very unfortunately, the laws pertaining to social media are, for want of a better word, lax at best. But on that note, Harshana Nanayakkara, we'll go for a short break, considering we started on time. And let's listen to what the headlines have got to say for this evening's Primetime News. We'll be back after this message.
Newsfirst, Newsline with Faraz Shauketaly.
And welcome back to Newsline Live. I'm in conversation with the Attorney at Law, Mr. Harshana Nanayakkara. Now then, Mr. Nanayakkara, what can somebody do who's being wrongfully accused and is basically a victim of what he perceives to be a malicious claim?
Well, firstly, he will have to face the case and get a ruling in his favor.
Yeah.
If it's a criminal case, a dismissal or acquittal. If it's a civil case, same form.
Yeah.
So once that happens, he can, I would suggest, consult a lawyer specializing in the area and see whether you have a case for malicious prosecution.
Right.
Not, as I told you earlier, not every dismissal of a case will automatically result in a
So if one is charged for murder and then turns up in court, blah, 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 and is finally cleared, can that give rise to a case of malicious prosecution against the police?
It all depends again the basis on which the acquittal was given.
Right.
Right? But however, it's going to be a tough job to show unless there are very special circumstances. It doesn't matter whoever made the complaint. It doesn't matter who did the investigation. It is the Attorney General who filed the indictment. I'm not saying the Attorney General is immune from malicious prosecution, but normally the Attorney General tend to, unless there are no other interferences, they tend to scientifically study the evidence.
Right.
So just because there's an acquittal, as I told you in the earlier segment, unless this fellow has been actively involved as a person to implicate falsely, there won't be action of malicious prosecution. Always you must remember, in this country, the conviction rate in criminal cases is around 5 to 6, 7%.
Right.
So about 90% of people get acquitted.
Right.
So just imagine the floodgates.
But that doesn't mean that 90% are all malicious
All malicious.
prosecutions.
Not at all. Not at all. There are millions of reasons why a case crashed.
Right.
Sometimes the witness can't recall them. Sometimes some document is destroyed. Sometimes the only available forensic evidence is missing. So there are a lot of other issues, not
Right.
just malice.
Right.
It's not automatic.
We've had a case recently where a member of the customs was released from, acquitted of the charges brought against him. And this is, of course, an alleged bribery case, but he was cleared. And do you think that that person might have a case for malicious prosecution, his reputation, and so on?
Might. He just might, depending on the circumstances. As I told you earlier, that fellow has to do something beyond the normal complaint to implicate him. He should have been activated by malice.
And in
Possible.
Sri Lanka, our laws, does it provide for enough legal remedies to take care of people who've been who've suffered because of a false, baseless claim, perhaps with malice,
Yes. Well, basically, I mean,
or malice and or a ulterior motive?
correct. Now, as I told you earlier, malice is also defined by when there's no reasonable or probable cause.
Yeah.
Activated completely, not just by ill will or spite,
Yeah.
but complete fabrication out of spite mainly. So we have the action of malicious prosecution,
Yeah.
where if you're successful in that, you can claim compensation and a civil court in monetary terms for your emotional stress or damage of reputation.
Yeah.
So those things are available in Sri Lanka, but the question you asked me was very broad. Do we have enough laws? I think yes, there may be some laws that need to be updated and expanded to be more modern. We still have the basic structure that we can work on.
And Sri Lanka seems to, our legal system sort of groans under the weight and so on. What is, the question is, and the Constitution seems to be on our side when we say this is one country, one law, the powers that be, this present government, the previous government, they all said the same thing. One country, one law, though the previous government may have made a bit of a mishmash about that by going and co-sponsoring that thing in Geneva. But forgetting that, this business about, this whole concept about one law, one country. As a practicing lawyer, would you agree that we actually truly have one law, one country?
Not really, because if you really look at it, when you say one law, one country, which is a political rhetoric to begin with, what we mean is rule of law. Everybody is treated equally before the law, regardless of caste, race, religion, or your financial status. So that's actually, that statement says we are a country who respect rule of law, but we jolly well know it doesn't happen here. So there's no rule of law. This is what I'm saying, I keep on saying. Now to answer some part of your question, I think I was thinking, now when we are studying in law school and LLB or wherever, we speak a lot of legal theory. We speak about Hart and Jeremy Bentham and whoever name it. But ultimately there's one old man called Marx. What he says remains true to date. That is, law is the will of the ruler, full stop. It is the will of the ruler. These laws are, I mean, we have heard IGP saying we will bend the law. Right, you have heard this. Laws are like the webs of a spider. The poor and weak get caught in them, but the rich and powerful break away from them.
But that statement you just made, that the laws are the will of the ruler, takes on a very potent and significant meaning now that Sri Lanka has the 20th Amendment. And that is really frightening for democracy.
Absolutely, because you see, a vibrant democracy, rule of law, can never run with without checks and balances. That's a crucial part. But right now, our parliament after the 20th Amendment is nothing but a rubber stamp. You heard some ministers saying, we don't know anything. It is just that this person is doing it. Some minister is saying about his own subject. So we can see now the government is not being run by the parliament, but by the executive. One might even wonder, are we being run by the executive, or is the executive being run by India, China and America? People might ask these questions.
Indeed.
But 20th Amendment is the death nail for democracy in this country. And we said it even before the 20th Amendment came. Now people are realizing what we said.
But it's always too late. It's now law.
It's law. See, that's the thing. Now, see, during the elections also we said that they were going to do it the moment they come into power. Right? And that's why we said not to vote for SJB at that time, that they will cross over at the right moment. But their constituent partners crossed over and gave the 2/3 required. So what I'm trying to say is that when people betray the will of the people, it's a betrayal of the will. When you cross over for us, what you're doing is you're betraying the will of the people. When people told you stay with Sajid's SJB, be the opposition you want to be, and then when you have 8 guys crossing over, there's a betrayal of the will of the people. So when your parliament is full of people who betray the will of the people, these things are inevitable. As you know, our NPP, quite unfortunately, we only have 3 people inside. So if there have at least 10 or 15 of us inside the parliament.
Why then are the people ignoring people from your party?
That's a very good question, because we feel we would like to ask them that question, why you are being ignored. The only thing I can think of is that our message is not going through properly sometimes downwards, and of course NPP is a very new outfit. And also people feel that...
But the JVP isn't a new outfit.
NPP is an outfit, new one, but we say that this is the truth and this is how we are going to go. We have a plan, we have a vision. At least one thing what we have said has come true now, that one man, one person cannot fix the problems of this country, that you need a team of honest individuals with integrity, the kind of people that you don't have much in the parliament of, very few.
One question that's relevant to the current context. How will the will of the ruler be perceived in the upcoming HR human rights sessions in Geneva?
That we will have to wait and see, but there'll be some pressures, not that there won't be, because I mean right now we are just basically playing into it. I mean, even if you look at the burial issue, when the entire world is saying burying COVID victims is not posing a threat, right? We and China are the only ones who are not allowing that. Now obviously human rights organizations are going to take on it. So basically this government, in their silly nature, they are playing into the hands of these big powers.
Why are they stuck in the mud for that? Why are they burying their heads in the sand? What's your take on it?
My take on it is just simply they have absolutely no idea what to do. They have this, quite unfortunately, let me put it this way, the collective intelligence of this government weighs less than a helium balloon, if you ask me. They are just plain, downright silly. They're asking for all these troubles. So when I say will of the ruler, now Marx is an old man, it's a very old theory, but that's true of any country. That's why it's important that we appoint rulers who are thinking of people, because ultimately law is going to be the will of the ruler. But we've been continuing to appoint people who don't think of the people, and then regret about it for the next 5 years till the next elections.
And by then, they'll be all swayed by the last speech.
And then they will vote again.
The same people. Including for 72 years after independence, coming up to 73, 582 schools have got no toilet facilities.
According to Harini, she's the one who does this.
Well, actually, the figure was given by Professor Gio Pires.
Most probably,
So that's a shame. And I think that all legislators since 1948 till today must hide in shame, because they have not sorted out those kids and their toilet facilities.
I mean, forget about everything. Look at this Middle Eastern worker who are struggling to come to this country for the last 1 year. They bring us 8 billion rupees a year in revenue. And this government and it's their friends charging them about 300,000 for the package to come here. The housemaids, they only earn 50,000 rupees a month. So isn't that a shame?
That's a shame
Absolutely.
too, and it needs urgently to be sorted and resolved. Harshana Nanayakkara, thank you very much for being on Newsline Live. And it's now time for that wonderful program, the Primetime News from News First. Take care and God bless you.